One of the most common questions we get from people who are charged with DUI, it's the first offense they've ever had, they've got no criminal record, they have no history at all. They ask, do I have to go to jail? Well, legally, in Arizona, according to the statute, according to the law, the answer is yes. It doesn't matter if it's your first time. It doesn't matter if it's a minor DUI or a major DUI. It doesn't matter how many puppies you raise, how many little old ladies you walk across the street. It doesn't matter how amazing of a person you are. According to the law, you have to go to jail. Arizona has some of the strictest DUI laws in the entire country, and so this can be very shocking to people. Why don't I get a break if it's my first offense? It's a good question. You should ask the people who write the laws, but according to the law as they're written today, if you're convicted of a DUI, you have to go to jail. And the way that the law is structured is the penalty increases with the severity of the DUI, and by severity I mean the higher that your blood alcohol content is, the more jail time that is going to be required. And so, if you have a citation, if you have a ticket for a DUI, you may see charges that look like this. I wrote them from the least serious up to the most serious. It's kind of counterintuitive. You'd think it might go the other way around because as your BAC goes higher, the penalties go up. But this is generally how we see them written on somebody's citation. And so the lowest level that we have is what's called impaired to the slightest degree. So this means it doesn't matter what your blood alcohol content is. If an officer says you were impaired, this is what they'll charge you with. And it's the lowest minor level. You can even be under the legal limit. Still, if you're convicted of this DUI charge, you have to go to jail. It starts at 10 days of jail. Okay, now most people don't serve full 10 days. There are ways to get that knocked down with substance abuse screening and those types of things, but that's where it starts. If you go up to the next level, so say for example, you see this on your citation and the officer says that your blood alcohol content was anything above a 0.08 but under a 0.15, the maximum jail time is 6 months, the minimum jail time is 10 days again. So these are the same in terms of penalties. As I said earlier, it doesn't mean you have to serve all 10, but you have to serve some jail time. It has to be in there. If it's up above a 0.15, this is called an extreme DUI, and the penalties go up significantly. The jail time, if you look in the statute, it starts at 30 days of jail. 30 days for an extreme DUI. The highest level DUI is what's called a super extreme DUI. That's not actually in the statute. This is something that we call it, but it's anything that's a 0.20 or above. So anything above a 0.20 all the way up to a point, we've seen them up in the 0.4s, meaning somebody's almost half of their blood was alcohol. Anything in that range starts at 45 days. This is for a first offense. So even if you're a first offense, this is you've never ever in your whole life ever been in trouble before, and you're charged with a super extreme DUI, you can look up the statute yourself, and it's going to say you have to go to jail for 45 days. Okay, there are ways you can get that number down. That's where defense attorneys come into play. I don't like this. You don't like this. The reason why you want to bring a defense team on board is to get these numbers down, to make it so that you don't have to go to jail. You don't have to have a criminal conviction. You don't have to have a criminal record. You don't have to have any of these very harsh mandatory penalties that are associated with DUIs. And we do that by knocking these numbers down. You can turn all of these numbers down into almost nothing, sometimes 0 days, depending on what court, what jurisdiction, what the facts of your case are, and what the mitigation looks like for you specifically. So if this sounds bad, it is bad. It's very harsh, and a lot of other states don't have mandatory jail. California, I'm licensed there as well. You can get a DUI there and not spend a day in jail. Arizona, you have no choice according to the statute. If you go into court and you plead guilty to DUI, say you don't hire an attorney, you don't think it's worth your time or your money, you go into court and plead guilty, you're going to be signing paperwork that says you have to report to jail in almost every single case. Unless something can get worked out, you're going to be going to jail, even if it's your first offense, even if it's a very low-level DUI. Starts at 10 days, and you can reduce some of those days down with substance abuse screening and those types of things. But at minimum, you still have to serve 24 hours or 1 day in jail, even for these two violations. So people ask all the time, do I have to go to jail? Legally, the answer is yes. According to the statute, yes, you have to go to jail. Practically, and in many of our cases that we represent people on, they don't go to jail. All right? Many of them don't get DUIs. Many of them are reduced from super extremes down to regulars or down to reckless driving charges, or they're just dismissed altogether, or they're acquitted at trial. So that's why it's important, before you decide what you're going to do, understand there is mandatory jail time. You might want to give us a call or another defense attorney a call. Make sure you speak with us. We'll offer a free case evaluation for you. We'll explain the strengths of your case, explain what some good defenses will be, and make sure you have a solid plan moving forward. Thanks for watching.